How can human rights challenge national approaches to citizenship?
Human rights limits everything a government does. Nothing is outside the coverage of human rights. And what we need to understand is that even when determining who is a citizen, a state is limited. A state has to respect rules of international law. And one of the easiest examples is, could the state decide that only white people can be citizens of a country? The short answer is absolutely not. There are human rights that limit the choice of a state in terms of citizenship. So a white-only rule of citizenship would clearly be discriminatory and maybe even be considered arbitrary. There's a number of human rights in the law. So that's an example. Another example would be, could a country, a government, decide that only Christians are entitled to be a citizen of that country? Once again, the answer has to be no. That kind of rule would be subject to also the prohibition of discrimination, could be considered arbitrary. So very clearly, when you have something so direct and so significant in terms of deciding who is a citizen, there are international rules of human rights that would be involved and would limit the sovereignty of the state. Simple as that. And the general prohibition of discrimination applies also to citizenship processes. So to be very specific, Article 26 of the Covenant on Civil and Political Rights, which has been accepted, has been ratified by most countries in the world, actually also applies to citizenship. So that is one of the most powerful human rights from a legal point of view, which is a legal obligation for most countries in the world that can be applied directly to citizenship. And I'm not sure why, but in fact, it's not often used as a legal argument when you clearly have citizenship requirements that are discriminatory on the basis of religion or ethnicity or even language. The other human rights, general human rights treaties that has been accepted by most governments in the world is the Convention on the Elimination of All Racial Discrimination that actually has a section, a provision, prohibiting racial discrimination in determining citizenship. Almost all governments in the world have ratified that treaty, accepted that treaty, and that applies to citizenship issues. There are some nuances there because in a way that treaty says governments are always allowed to distinguish between a citizenship and a non-citizenship, but still, that treaty actually is directly relevant and applicable when a government makes it more difficult for someone of a particular ethnic or religious group to achieve or to prove their citizenship. So those are the two, in my view, strongest, most directly relevant human rights that are applicable to issues of citizenship, including denial of citizenship, but quite often they're actually not talked about or actually raised. And I think this is because too often people will say, well, citizenship is protected under the Universal Declaration of Human Rights. That's a legal mistake. The Universal Declaration is not a treaty, it's not legally binding, and therefore we should really look at what are the legal obligations in international law of different countries. So in a nutshell, that would be the most important directly applicable human rights in relation to determining who is a citizen or determining if a citizenship requirement is acceptable in terms of international law.
Can you give me some examples on how this can be applied to citizenship determination process?
In India recently, you've had new legislation that provides for a fast track, an accelerated way to a procedure to become a citizen of India if you were part of a persecuted religious group in particular. So if you are a Christian refugee or a person who was persecuted in a neighboring country, you can apply for becoming a citizen of India in a faster way, if you will. As are other groups, religious groups, except there is one exception, and the one exception are Muslims. Muslims cannot obtain citizenship in India on an accelerated pathway because the legislation says that they're not considered to be persecuted by neighboring countries. In terms of human rights, this could be seen to be discriminatory because it excludes members of a particular religious group who can objectively be persecuted for their beliefs in other countries or neighboring countries. It is a difference of treatment on the ground of religion, which I would suggest is clearly in international law unreasonable and therefore discriminatory. because even within Islam, you have different traditions, different practices, and some of them are in fact persecuted in neighboring countries of India. So this is a demonstration of the way you can apply international human rights to protect, or prohibit rather, unreasonable, unfair, or unjust differences of treatment based on this particular example on religious differences. There is also areas such as documentary requirements. You have to prove, once again, in this case in India, in Assam, there's a process which requires a very large number of documents to demonstrate that you've lived in Assam legally for a long period of time. Now, all of this, those requirements do not seem to be arbitrary, because they actually require someone to prove objectively that they're connected, if you will, to Assam in India. But it could still be discriminatory in relation to how it is applied in practice. In practice, and we have, I say we in terms of the United Nations Special Rapporteur on Minority Issues, we had cases, allegations of violations. And we saw that there seems to be a difference of treatment depending on if someone has a Bengali-sounding name or is obviously Muslim. The kind of requirements that were demanded of them seem to be more onerous, more difficult, more demanding than those of Hindu background. So that could also be seen as being discriminatory in terms of the way the various requirements were applied in practice in Assam, India, and therefore be violations of international human rights law because they're discriminatory.